There's a lot of movement already inside court, no surprises here. But it's also worth pointing out that this is a bail verification hearing, which means a few more steps still need to be taken before we get to the merits of this trial.
Well, a very good morning to Ayanda, and yes, we are coming to you live from courtroom 11, where we are expecting the five of the seven suspects to appear in the Durban Magistrate court. I can tell you that it's already starting to get packed. We've got several media houses here. We've also got some organizations, also possibly from Women's League, here present in court. Various journalists also waiting to take their seats. We are expecting that it's going to be starting at 9:30 this morning. But yes, we are talking bail verification process, Ayana, this morning. And what does that mean? That means that the accused will have to prove that they are not a flight risk in this court, and will also have to wait and see whether some of them are also still having outstanding pending cases against them, and how that's going to work with regards to this murder case. But to break this down for us more, I'm joined by our legal expert, Abigail Ngobeni. Thank you so much for joining us, Abigail. We're talking verification process here. We've got a mastermind and a coordinator, Mr. Gwabi. He's got no case against him. But if we break this down in layman's terms and in terms of the law, how do they fare, all five of them, with regards to attaining bail?
Well, you see, when we talk a bail application, particularly a Schedule 6 offense, we need to follow what we call a two-stage kind of processes, where the accused person bears the honors to come and say there are exceptional circumstances, which, when we have regard to the interest of justice, permits their release on bail. So the fact that one does not have previous convictions or pending cases is not the only factor that contributes. Section 64 of the Criminal Procedure Act thus shows the factors that the court should take into consideration, and it particularly says or more of those factors are available, then it may not be considered to be in the interest of justice for a person to be admitted to bail. And in this particular case, when we talk of a mastermind, we talk of a gentleman. I don't know to the extent of the evidence, but when they call you a coordinator, it means you have been coordinating the movements, you know who is where and what time. Some of the factors that are being considered is whether or not are you not going to jeopardize the investigations further if you were to be admitted to bail. So it also plays a very important factor. So the court looks at Section 60, subsection 4, if I'm not mistaken, in holistic, with all the factors that shows what is it when we talk of the interest of justice.
Now, we also know that 4 of the 7 suspects are related, the Ndimande family, and 2 of them are in Eswatini. If we look at the other 2 that are in court, will that not jeopardize them in terms of attaining bail?
You see, in as much as in South Africa we have what we call a doctrine of a common purpose, that is another thing. But the fact that they are related does not play a role here. We deal with them as individuals. That's why they are charged accused number 1, number 2, up to number 5, that which we have today. The ones that are in Eswatini will be joined and be accused number 6 and 7 when they come here. They will be treated as individuals. That's why their fingerprints will be taken as individuals. So they'll have to account for their role and activities in the entire processes, and also the charges that they are also linked to will be individual charges as per person as they stand before the court. So their relation, whether they are brothers or siblings, does not necessarily play a role. We check what is there in the police docket, what was their role, what are they charged with, and we take it from there.
And I imagine that we're only going to be dealing with a few of the suspects with regards to attaining bail, because 2 of the other suspects also have pending cases against them.
Yes, if there are those who are having pending cases and or perhaps they are convicted, they are already in prison for something else, it's going to be futile for them to apply for bail at this particular court, because even if court can admit them on bail on this one, if they are convicted or they for other matters where they are not admitted to bail or they are not released, they'll still go back to prison. So with my experience, when a person has already been convicted, they are likely to abandon bail at this stage.
Last question, Mrs. Ngobani. Just if we look at the strategy in which the police apprehended these suspects. Police have not ruled out the fact that they possibly could be arresting more individuals. And as the media, we have been punting that no arrests have been made, but police were working very tirelessly and arrested the individuals last year. 2 of the suspects, if I'm not mistaken, another 2 in February this year. In your view, and just looking at the way in which police have went about this, their strategy in arresting these suspects, talk to us about that.
They call it a parallel strategy. They go and link them to other cases, put them behind bars, link them to other cases and put them behind bars, while they know that they are trying to link them to this case. I should say it's one of its own kind of a strategy, but I applaud them for the kind of strategy they used. It seemed to have worked better for them because they were able to catch them, keep them in prison while they tighten their case. Then what we're expecting from them is a quality of evidence to say from April last year when they confiscated the first car until today, they must be having a volume of evidence, not information, because information may not necessarily be evidence. Evidence needs to qualify in the court of law and be found to be admissible, which can also be relied upon to secure a successful conviction. So what I'm saying is their strategy worked well because I think it helped them to have these accused persons kept in prison until they are finally brought to court and charged. Remember that the accused person have a right to appear in court within 48 hours when they are charged. But because these ones were already in prison, it would have been easier for them to charge them, appear within 48 hours and be brought back to prison without having to worry about the issues of whether or not we need to rush bail, or they are already in prison, so they can deal with them in a manner that is fair and just when they are here.
Thank you very much, legal expert Abigail Ngubeni, just breaking down the nitty-gritties for us. To be very interesting once court starts. I can see a lot of people are starting to make their way in, and we are dealing with bail verification process. Like our legal expert says here, they're going to be ensuring that they go through each and every suspect, look at their portfolio, and it's really up to them, Ayanda, to prove to this court that they are not a flight risk so that they can attain bail.